Hey crew, it's Pitt, and I am back with the final installment of our energetic investment into the reading aloud of the Federalist Papers. We are reading aloud today from Federalist Paper number 81, 82, 83, 84, and 85, most of which deals with the judicial, but there's a few wrap-ups at the end. There will be discussion between the papers, but I will try to keep it to a minimum, and let's dig in. This is going to be a long video. The Judiciary continued, and the distribution of the judicial authority, from Maclean's edition, New York, authored by Alexander Hamilton, to the people of the state of New York. Let us now return to the partition of the judiciary authority between different courts, and their relations to each other. The judicial power of the United States is, by the plan of the Convention, to be vested in one Supreme Court, and in such inferior courts as the Congress may, from time to time, ordain and establish. That there ought to be one court of supreme and final jurisdiction is a proposition which is not likely to be contested. The reasons for it have been assigned in another place and are too obvious to need repetition. The only question that seems to have been raised concerning it is whether it ought to be a distinct body or a branch of the legislature. The same contradiction is observable in regard to this matter which has been remarked in several other cases. The very men who object to the Senate as a court of impeachments on the ground of an improper intermixture of powers advocate, by implication at least, the propriety of vesting the ultimate decision of all causes in the whole or in a part of the legislative body. The arguments, or rather suggestions, upon which this charge is founded are to this effect. The authority of the proposed Supreme Court of the United States, which is to be a separate and independent body, will be superior to that of the legislature. The power of construing the laws according to the spirit of the Constitution will enable that court to mold them into whatever shape it may think proper, especially as its decisions will not be in any manner subject to the revision or correction of the legislative body. This is as unprecedented as it is dangerous. In Britain, the judicial power, in the last resort, resides in the House of Lords, which is a branch of the legislature. And this part of the British government has been imitated in the state constitutions in general. The Parliament of Great Britain and the legislatures of the several states can at any time rectify by law the exceptionable decisions of their respective courts. But the errors and usurpations of the Supreme Court of the United States will be uncontrollable and remediless. This, upon examination, will be found to be made up altogether of false reasoning upon misconceived fact. In the first place, there is not a syllable in the plan under consideration which directly empowers the national courts to construe the laws according to the spirit of the Constitution, or which gives them any greater latitude in this respect than may be claimed by the courts of every state. I admit, however, that the Constitution ought to be the standard of construction for the laws, and that wherever there is an evident opposition, the laws ought to give place to the Constitution. But this doctrine is not deducible from any circumstance peculiar to the plan of the Convention, but from the general theory of a limited Constitution, and as far as it is true, is equally applicable to most, if not all, state governments. There can be no objection, therefore, on this account, to the federal jurisdiction which will lie not against the local jurisdictions in general, and which will not serve to condemn every constitution that attempts to set bounds to legislative discretion. But perhaps the force of the objection may be thought to consist in the particular organization of the Supreme Court, in its being composed of a distinct body of magistrates, instead of being one of the branches of the legislature, as in the government of Great Britain and that of the state. To insist upon this point, the authors of the objection must renounce the meaning they have labored to annex to the celebrated maxim, requiring a separation of the departments of power. It shall, nevertheless, be conceded to them, agreeably to the interpretation given to the maxim in the course of these papers, that it is not violated by vesting the ultimate power of judging in a part of the legislative body. But though this be not an absolute violation of the excellent rule, yet it verges so nearly upon it as, on this account alone, to be less eligible than the mode preferred by the Convention. From a body which had even a partial agency in passing bad laws, we could rarely expect a disposition to temper and moderate them in the application. The same spirit which had operated in making them would be too apt in interpreting them. Still less could be expected that the men who had infringed on the Constitution in the character of legislators would be disposed to repair the breach in the character of judges. Nor is this all. Every reason which recommends the tenure of good behavior for judicial offices militates against placing the judiciary power, in the last resort, in a body composed of men chosen for a limited period. There is an absurdity in referring the determination of causes, in the first instance, to judges of permanent standing, in the last to those of temporary and mutable constitution. And there is a still greater absurdity in subjecting the decisions of men, selected for their knowledge of the laws acquired by long and laborious study, to the revision and control of men who, for want of the same advantage, cannot but be deficient in that knowledge. The members of the legislature will rarely be chosen with a view to those qualifications which fit men for the stations of judges. And as, on this account, there will be great reason to apprehend all the ill consequences of defective information, so, on account of the natural propensity of such bodies to party divisions, there will be no less reason to fear that the pestilential breath of faction may poison the fountains of justice. The habit of being continually marshaled on opposite sides will be too apt to stifle the voice of both law and of equity. These considerations teach us to applaud the wisdom of those states who have committed the judicial power, in the last resort, not to a part of the legislature, but to distinct and independent bodies of men. Contrary to the supposition of those who have represented the plan of the convention, in this respect, as novel and unprecedented, it is but a copy of the constitutions of New Hampshire, Massachusetts, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia, and the preference which has been given to those models is highly to be commended. It is not true, in the second place, that the Parliament of Great Britain or the legislatures of the particular states can rectify the exceptionable decisions of their respective courts in any other sense than might be done by a future legislature of the United States. The theory, neither of the British nor of the state constitutions, authorizes the revisal of a judicial sentence by a legislative act. Nor is there anything in the proposed Constitution, more than in either of them, by which it is forbidden. In the former, as well as in the latter, the impropriety of the thing, on the general principles of law and reason, is the sole obstacle. A legislature, without exceeding its province, cannot reverse a determination once made in a particular case, though it may prescribe a new rule for future cases. This is the principle, and it applies in all its consequences, exactly in the same manner and extent, to the state governments, as to the national government now under consideration. Not the least difference can be pointed out in any view of the subject. It may be in the last place to be observed that the supposed danger of judiciary encroachment on the legislative authority, which has been upon many occasions reiterated, is in reality a phantom. Particular misconstructions and contraventions of the will of the legislature may now and then happen, but they can never be so extensive as to amount to an inconvenience, or in any sensible degree to affect the order of the political system. This may be inferred with certainty from the general nature of the judicial power, from the objects to which it relates, from the manner in which it is exercised, from its comparative weakness, and from its total incapacity to support its usurpations by force. And the inference is greatly fortified by the consideration of the important constitutional check which the power of instituting impeachments on one part of the legislative body, and of determining upon them in the other, would give to that body upon the members of the judicial department. This is alone a complete security. There never can be danger that the judges, by a series of deliberate usurpations on the authority of the legislature, would hazard the united resentment of the body entrusted with it, while the body was possessed of the means of punishing their presumption, by degrading them from their stations. While this ought to remove all apprehensions on the subject, it affords, at the same time, a cogent argument for constituting a Senate, a court for the trial of impeachments. Having now examined and, I trust, removed the objections to the distinct and independent organizations of the Supreme Court, I proceed to consider the propriety of the power of constituting inferior courts, and the relations which will subsist between these and the former. The power of constituting inferior courts is evidently calculated to obviate the necessity of having recourse to the Supreme Court in every case of federal cognizance. It is intended to enable the national government to institute or authorize in each state or district of the United States a tribunal competent to the determination of matters of national jurisdiction within its limits. But why, it is asked, might not the same purpose have been accomplished by the instrumentality of the state courts? This admits of different answers. Though the fitness and competency of those courts should be allowed in the utmost latitude, yet the substance of the power in question may still be regarded as a necessary part of the plan, if it were only to empower the national legislature to commit to them the cognizance of causes arising out of the national constitution. To confer the power of determining such causes upon the existing courts of the several states would perhaps be as much as to constitute tribunals, as to create new courts with the like power. But ought not a more direct and explicit provision to have been made in favor of the state courts? There are, in my opinion, substantial reasons against such a provision. A most discerning cannot foresee how far the prevalency of a local spirit may be found to disqualify the local tribunals for the jurisdiction of national causes, whilst every man may discover that courts constituted like those of some of the states would be improper channels of the judicial authority of the Union. State judges, holding their offices during pleasure or from year to year, will be too little independent to be relied upon for an inflexible execution of the national laws. And if there was a necessity for confiding in the original cognizance of causes arising under those laws to them, there would be a correspondent necessity for leaving the door of appeal as wide as possible. In proportion to the grounds of confidence in or distrust of the subordinate tribunals, ought to be the facility or difficulty of appeals, and well satisfied as I am of the propriety of the appellate jurisdiction in the several classes of causes which it is extended by the plan of the convention, I should consider everything calculated to give, in practice, an unrestrained course to appeals as a source of public and private inconvenience. I am not sure but that it will be found highly expedient and useful to divide the United States into 4 or 5 or half a dozen districts, to institute a federal court in each district, in lieu of one in every state. The judges of these courts, with the aid of the state judges, may hold circuits for the trial of causes in the several parts of the respective districts. Justice through them may be administered with ease and dispatch, and appeals may be safely circumscribed within a narrow compass. This plan appears to me at present to be the most eligible of any that could be adopted, and, in order to it is necessary that the power of constituting inferior courts should exist in the full extent in which it is to be found in the proposed Constitution. These reasons seem sufficient to satisfy a candid mind that the want of such a power would have been a great defect in the plan. Let us now examine in what manner the judicial authority is to be distributed between the supreme and inferior courts of the Union. The Supreme Court is to be invested with the original jurisdiction only in cases affecting ambassadors or other public ministers and consuls, and those in which a state shall be a party. Public ministers of every class are the immediate representatives of their sovereigns. All questions in which they are concerned are so directly connected with the public peace that, as well as for the preservation of this, as out of respect to the sovereignties they represent, it is both expedient and proper that such questions should be submitted in the first instance to the highest judiciary of the nation. Though consuls have not in strictness a diplomatic character, yet as they are the public agents of the nations to which they belong, the same observation is in a great measure applicable to them. In cases in which a state might happen to be a party, it would ill suit its dignity to be turned over to an inferior tribunal, though it may rather be a digression from the immediate subject of this paper. I shall take occasion to mention here a supposition which has excited some alarm upon very mistaken grounds. It has been suggested that an assignment of the public securities of one state to the citizens of another would enable them to prosecute the state in the federal courts for the amount of those securities, a suggestion which the following considerations prove to be without foundation. It is inherent in the nature of sovereignty not to be amenable to the suit of an individual without its consent. This, in the general sense and the general practice of mankind, and the exemption, as one of the attributes of sovereignty, is now enjoyed by the government of every state in the Union. Unless, therefore, there is a surrender of this immunity in the plan of the convention, it will remain with the states, and the danger intimated must be merely ideal. The circumstances which are necessary to produce an alienation of state sovereignty were discussed in considering the article of taxation, and need not be repeated here. A recurrence to the principles there established will satisfy us that there is no color to pretend that the state governments would, by the adoption of that plan, be divested of the privilege of paying their own debts in their own way, free from every constraint but that which flows from the obligations of good faith. The contracts between a nation and individuals are only binding on the conscience of the sovereign, and have no pretensions to a compulsive force. They confer no right of action independent of the sovereign will. To what purpose would it be to authorize suits against the United States for the debts they owe? How could recoveries be enforced? It is evident it could not be done without waging war against the contracting state, and to ascribe to the federal courts, by mere implication, and in destruction of a pre-existing right of the state governments, a power which would involve such a consequence would be altogether forced and unwarrantable. Let us resume the train of our observations. We have seen that in the original jurisdiction of the Supreme Court would be confined to two classes of causes, and those of a nature rarely to occur. In all other cases of federal cognizance, the original jurisdiction would appertain to the inferior tribunals, and the Supreme Court would have nothing more than an appellate jurisdiction, with such exceptions and under such regulations as the Congress shall make. The propriety of this appellate jurisdiction has been scarcely called in question in regard to matters of law, but the clamors have been loud against it as an applied matters of fact. Some well-intentioned men in this state, deriving their notions from the language and forms which obtain in our courts, have been induced to consider it as an implied supersedure of the trial by jury, in favor of the civil law mode of trial, which prevails in our courts of admiralty, probate, and chancery. A technical sense has been affixed to the term appellate, which, in our law parlance, is commonly used in reference to appeals in the course of the civil law. If I am not misinformed, the same meaning would not be given to it in any part of New England. There an appeal from one jury to another is familiar in both language and practice, and is even in a matter of course, until there have been two verdicts in one side. The word appellate, therefore, will not be understood in the same sense in New England as in New York, which shows the impropriety of a technical interpretation derived from the jurisprudence of any particular state. The expression, taken in the abstract, denotes nothing more than the power of one tribunal to review the proceedings of another, either as to the law or fact, or both. The mode of doing it may depend on ancient custom or legislative provision. In a new government it must depend on the latter, and may be with or without the aid of a jury, as may be judged advisable. If, therefore, the re-examination of a fact once determined by a jury should be in any case be admitted under the proposed Constitution, it may be so regulated as to be done by a second jury, either by remanding the cause to the court below for a second trial of the fact, or by directing an issue immediately out of the Supreme Court. But it does not follow that the re-examination of a fact once ascertained by a jury will be permitted in the Supreme Court. Why may not it be said with the strictest propriety, when a writ of error is brought from an inferior to superior court of law in this state, that the latter has jurisdiction of the fact as well as the law? It is true it cannot institute a new inquiry concerning the fact, but it takes cognizance of it as it appears upon the record and pronounces the law arising upon it. This is jurisdiction of both fact and law, nor is it even possible to separate them. Though the common law courts of this state ascertain disputed facts by a jury, yet they unquestionably have jurisdiction of both fact and law. And, accordingly, when the former is agreed in the pleadings, they have no recourse to a jury, but proceed at once to judgment. I contend, therefore, on this ground, that the expressions appellate jurisdiction, both as to law and fact, do not necessarily imply a re-examination in the Supreme Court of the facts, decided by juries in the inferior courts. The following train of ideas may well be imagined to have influenced the convention in relation to this particular provision. The appellate jurisdiction of the Supreme Court, it may have been argued, will extend to causes determinable in different modes, some in the course of the common law, others in the course of the civil law. In the former, the revision of the law only will be, generally speaking, the proper province of the Supreme Court. In the latter, the re-examination of the fact is agreeable to usage, and in some cases, of which prize causes are an example, might be essential to the preservation of the public peace. It is therefore necessary that the appellate jurisdiction should, in certain cases, extend in the broadest sense of matters to matters of fact. It will not answer to make an express exception of cases which have been originally tried by the jury, because in the courts of some of the states all causes are tried in this mode, and such an exception would preclude the revision of matters of fact as well where it may be proper as well as where it might be improper. To avoid all inconveniences, it will be safest to declare generally that the Supreme Court shall possess appellate jurisdiction both as to law and fact, and that jurisdiction shall be subject to such exceptions and regulations as the national legislature may prescribe. This will enable the government to modify it in such a manner as will best answer the ends of the public justice and security. This view of the matter, at any rate, puts it out of all doubt that the supposed abolition of the trial by jury by the operation of this provision is fallacious and untrue. The legislature of the United States would certainly have full power to provide that in appeals to the Supreme Court there should be no re-examination of facts where they had been tried in the original causes by juries. This would certainly be an authorized exception, but if, for the reason of already intimated, it should be thought too extensive, it might be qualified with a limitation to such causes as only are determinable at common law in that mode of trial. The amount of observations hitherto made on the authority of the judicial department is this, that it has been carefully restricted to those causes which are manifestly proper for the cognizance of the national judicature, and that in the fruition of this authority a very small portion of the original jurisdiction has been preserved to the Supreme Court, and the rest consigned to the subordinate tribunals, that the Supreme Court will possess an appellate jurisdiction, both as to law and fact, and, in all the cases referred to them, both subject to any exceptions and regulations which may be thought advisable, that this appellate jurisdiction does, in no case, abolish the trial by jury, and that an ordinary degree of prudence and integrity in the national councils will ensure us solid advantages from the establishment of the proposed judiciary, without exposing us to any of the inconveniences which have been predicted from that source. And so ends Federalist Paper number 81. And we got the majority of the objections being that the Supreme Court would be too powerful. They would get rid of the trial by jury. They would be able to overturn at will. And we have seen through history that that's not the case, that it takes very, very pressing and extreme circumstances for them to even consider any of the cases that they consider, and that they are very reluctant to change the appellate decisions, and so our faith in them seems for the most part to be of fairly good faith, right? The court has been executed in the manner it was intended as laid out here, and it has followed the rules fairly well throughout the years. Federalist Paper number 82, The Judiciary Continued, from McLean's edition, New York, authored by Alexander Hamilton, to the people of the state of New York. The erection of a new government, whatever care or wisdom may distinguish the work, cannot fail to originate questions of intricacy and nicety, and these may, in a particular manner, be expected to flow from the establishment of a constitution founded upon the total or partial incorporation of a number of distinct sovereignties. It is time only that can mature and perfect so compound a system, can liquidate the meaning of all the parts, and can adjust them to each other in a harmonious and consistent whole. Such questions, accordingly, have arisen upon the plan proposed by the Convention, and particularly concerning the Judiciary Department. The principal of these respect the situation of the state courts in regard to those causes which are to be submitted to federal jurisdiction. Is this to be exclusive, or are those courts to possess a concurrent jurisdiction? If the latter, in what relation will they stand to the national tribunals? These are inquiries which we will meet with in the mouths of men of sense, which certainly entitle to attention. The principles established in a former paper teach us that the states will retain all pre-existing authorities which may not be exclusively delegated to the federal head, and that this exclusive delegation can only exist in one of three cases: where an exclusive authority is, in express terms, granted to the Union, or where a particular authority is granted to the Union and the exercise of a like authority is prohibited to the states, or where an authority is granted to the Union with which a similar authority in the states would be utterly incompatible. Though these principles may not apply with the same force to the judiciary as the legislative power, yet I am inclined to think that they are, in the main, just with respect to the former as well as the latter. And under this impression I shall lay it down as a rule, that the state courts will retain the jurisdiction they now have, unless it appears to be taken away in one of the enumerated modes. The only thing in the proposed Constitution which wears the appearance of confining the causes of federal cognizance in the federal courts is contained in this passage: the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress shall from time to time ordain and establish. This might either be construed to signify that the supreme and subordinate courts of the Union should alone have the power of deciding those causes to which their authority is to extend, or simply to denote that the organs of the national judiciary should be one Supreme Court, and as many subordinate courts as Congress should think proper to appoint, or, in other words, that the United States should exercise the judicial power with which they are to be invested, through one supreme tribunal, and a certain number of inferior ones to be instituted by them. The first excludes, the last admits, the concurrent jurisdiction of the state tribunals, and as the first would amount to an alienation of state power by implication, the last appears to me the most natural and most defensible construction. But this doctrine of concurrent jurisdiction is only clearly applicable to those descriptions of causes of which the state courts have previous cognizance. It is not equally evident in relation to cases which may grow out of and be peculiar to the Constitution to be established. For not to allow the state courts a right of jurisdiction in such cases can hardly be considered as the abridgment of a pre-existing authority. I mean, not therefore to contend with the United States in the course of legislation upon the objects entrusted to their direction, may not commit the decision of causes arising upon a particular regulation to the federal courts solely, if such a measure should be deemed expedient. But I hold that the state courts will be divested of no part of their primitive jurisdiction, further than may relate to an appeal, and I am even of opinion that in every case in which they are not expressly excluded by the future acts of the national legislature, they will, of course, take cognizance of the causes to which these acts may give birth. This I infer from the nature of judiciary power, and from the general genius of the system. The judiciary power of every government looks beyond its own local or municipal laws and, in civil cases, lays hold of all subjects of litigation between parties within its jurisdiction, though the causes of dispute are relative to the laws of the most distant part of the globe. Those of Japan, not less than of New York, may furnish the objects of legal discussion to our courts. When, in addition to this, we consider the state governments and the national governments as they truly are, in the light of kindred systems and as parts of one whole, the inference seems to be conclusive that the state courts would have a concurrent jurisdiction in all cases arising under the laws of the Union, where it was not expressly prohibited. Here another question occurs. What relation would subsist between the national and state courts in these instances of concurrent jurisdiction? I answer that an appeal would certainly lie from the latter to the Supreme Court of the United States. The Constitution, in direct terms, gives an appellate jurisdiction to the Supreme Court in all the enumerated cases of federal cognizance in which it is not to have an original one, without a single expression to confine its operation to the inferior federal courts. The objects of appeal, not the tribunals from which it is to be made, are alone contemplated. From this circumstance and from the reason of the thing, it ought to be construed to extend to the state tribunals. Either this must be the case, or the local courts must be excluded from a concurrent jurisdiction in matters of national concern. Else, the judiciary authority of the Union may be eluded at the pleasure of every plaintiff or prosecutor. Neither of these consequences ought, without evident necessity, to be involved. The latter would be entirely inadmissible, as it would defeat some of the most important and avowed purposes of the proposed government, and would essentially embarrass its measures. Nor do I perceive any foundation for such a supposition. Agreeably to the remark already made, the national and state systems are to be regarded as one whole. The courts of the latter will, of course, be natural auxiliaries to the execution of the laws of the Union, and an appeal from them will as naturally lie to that tribunal which is destined to unite and assimilate the principles of national justice and the rules of national decisions. The evident aim of the plan of the convention is that all the causes of the specified classes shall, for weighty public reasons, receive their original or final determination in the courts of the Union. To confine, therefore, the general expressions giving appellate jurisdiction to the Supreme Court to appeals from the subordinate federal courts, instead of allowing their extension to the state courts, would be to abridge the latitude of the terms, in subversion of the intent, contrary to every sound rule of interpretation. But could an appeal be made to lie from the state courts to the subordinate federal judicatories? This is another of the questions which have been raised, and of greater difficulty than the former. The following considerations countenance the affirmative. The plan of the convention, in the first place, authorizes the national legislature to constitute tribunals inferior to the Supreme Court. It declares, in the next place, that the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress shall ordain and establish. And it then proceeds to enumerate the cases to which this judicial power shall extend. It afterwards divides the jurisdiction of the Supreme Court into original and appellate, but gives no definition of the subordinate courts. The only outlines described for them are that they shall be inferior to the Supreme Court, and that they shall not exceed the specified limits of the federal judiciary. Whether their authority shall be original or appellate or both is not declared. All this seems to be left to the discretion of the legislature, and, this being the case, I perceive at present no impediments to the establishment of an appeal from the state courts to the subordinate national tribunals. And many advantages attending the power of doing it may be imagined. It would diminish the motives of the multiplication of federal courts and would admit of arrangements calculated to contract the appellate jurisdiction of the Supreme Court. The state tribunals may then be left with a more entire charge of federal causes and appeals, in most cases in which they may be deemed proper, instead of being carried to the Supreme Court, may be made to lie from the state courts to district courts of the Union. And so ends Federalist Paper number 82, and it seems that people again were very much concerned that the federal court would take precedence completely away from the state courts, that it would take the right to try because they could form these smaller courts that were now used almost exclusively as appellate courts. That was the intention of them, but it was not well understood, and this seems to be an argument for that. It is fairly cogent, right? It makes sense. It has worked for 250 years, so there's not a whole lot to add to that. The Federalist Paper number 83, and we're going to see how my voice holds up because this might be the end of it for today. The Judiciary continued in relation to trial by jury from McLean's edition, New York, authored by Alexander Hamilton, to the people of the state of New York. The objection to the plan of the convention, which has met with most success in this state and perhaps in several of the other states, is that relative to the want of a constitutional provision for the trial by jury in civil cases. This disingenuous form in which this objection is usually stated has been repeatedly adverted to and exposed, but continues to be pursued in all the conversations and writings of the opponents of the plan. The mere silence of the Constitution in regard to civil causes is represented as an abolition of the trial by jury, and the declamations to which it has afforded a pretext are artfully calculated to induce a persuasion that this pretended abolition is complete and universal, extending not only to every species of civil but even to criminal causes. To argue with respect to the latter would, however, be in vain and fruitless as to attempt the serious proof of the existence of matter, or to demonstrate any of those propositions which, by their own internal evidence, force conviction when expressed in language adapted to convey their meaning. With regard to civil causes, subtleties almost too contemptible for refutation have been employed to countenance the surmise that a thing which is not only provided for, but is entirely abolished. Which is only not provided for, is entirely abolished. Every man of discernment must at once perceive the wide difference between silence and abolition. But, as the inventors of this fallacy have attempted to support it by certain legal maxims of interpretation, which they have perverted from their true meaning, it may not be wholly useless to explore the ground they have taken. The maxims on which they rely are of this nature. A specification of particulars is an exclusion of generals, or the expression of one thing is the exclusion of another. Hence, they say, as the Constitution has established the trial by jury in criminal cases, and is silent in respect to civil, this silence is an implied prohibition of trial by jury in regard to the latter. The rules of legal interpretation are rules of common sense, adopted by the courts in the construction of the laws. The true test, therefore, of a just application of them is its conformity to the source from which they are being derived. This being the case, let me ask if this is consistent with common sense to suppose that a provision obliging the legislative power to commit the trial of criminal causes to juries is a privation of its right to authorize or permit that mode of trial in other cases. Is it natural to suppose that a command to do one thing is a prohibition of doing another, which there was a previous power to do, and which is not incompatible with the thing commanded to be done? If such a supposition would be unnatural and unreasonable, it cannot be rational to maintain that an injunction of the trial by jury in certain cases is an interdiction of it in others. A power to constitute courts as a power to prescribe the mode of trial and consequently, if nothing was said in the Constitution on the subject of juries, the legislature would be at liberty either to adopt that institution or to let it alone. This discretion in regard to criminal clauses is abridged by the express injunction of trial by jury in all such cases. But it is, of course, left at large in relation to civil causes, there being a total silence on its head. The specification of an obligation to try all criminal causes in a particular mode excludes, indeed, the obligation or necessity of employing the same mode in civil causes, but does not abridge the power of the legislature to exercise that mode if it should be thought proper. The pretense, therefore, that the national legislature would not be at full liberty to submit all the civil causes of federal cognizance to the determination of juries is a pretense destitute of all just foundation. Sorry. From these observations, this conclusion results: that the trial by jury in civil cases would not be abolished, and that the use attempted to be made of the maxims which have been quoted is contrary to reason and common sense, and therefore not admissible, even if these maxims had a precise technical sense corresponding with the ideas of those who employ them upon the present occasion, which, however, is not the case. They would still be inapplicable to a constitution of government. In relation to such a subject, the natural and obvious sense of its provisions, apart from any technical rules, is the true criterion of construction. Having now seen that the maxims relied upon will not bear the use made of them, let us endeavor to ascertain their proper use and true meaning. This will be done by examples. The plan of the convention declares that the power of Congress, or, in other words, the national legislature, shall extend to certain enumerated cases. This specification of particulars evidently excludes all pretension to a general legislative authority, because an affirmative grant of special powers would be absurd, as well as useless, if a general authority was intended. In like manner, the judicial authority of the federal judicatures is declared by the Constitution to comprehend certain cases particularly specified. The expression of those cases marks the precise limits beyond which the federal courts cannot extend their jurisdiction, because the objects of their cognizance are being enumerated. The specification would be nugatory if it did not exclude all ideas of more extensive authority. These examples are sufficient to elucidate the maxims which have been mentioned and to designate the manner in which they should be used. But, that there may be no misapprehensions upon this subject, I shall add one case more, to demonstrate the proper use of these maxims and the abuse which has been made of them. Let us suppose that, by the laws of this state, a married woman was incapable of conveying her estate, and that the legislature, considering this as an evil, should enact that she might dispose of her property by deed executed in the presence of a magistrate. In such a case there can be no doubt but the specification would amount to an exclusion of any other mode of conveyance, because the woman, having no previous power to alienate her property, the specification determines the particular mode which she is, for that purpose, to avail herself of. But let us further suppose that in a subsequent part of the same act it should be declared that no woman should dispose of any estate of a determinate value without the consent of 3 of her nearest relations, signified by their signing the deed. Could it be inferred from this regulation that a married woman might not procure the approbation of her relations to a deed for conveying property of inferior value? The position is too absurd to merit a refutation, and yet this is precisely the position of those must establish who contend that the trial by juries in civil cases is abolished, because it is expressly provided for in cases of a criminal nature. From these observations, it must appear unquestionably true that trial by jury is in no case abolished by the proposed Constitution, and it is equally true that in those controversies between individuals in which the great body of the people are likely to be interested, that institution will remain precisely in the same situation in which it is placed by the state constitutions, and will in no degree alter, will be in no degree altered or influenced by the adoption of the plan under consideration. The foundation of this assertion is that the national judiciary will have no cognizance of them, and of course they will remain determinable as heretofore by the state courts only, and in the manner which the state constitutions and laws prescribe. All land causes, except where claims under the grants of different states come into question, and all other controversies between the citizens of the same state, unless where they depend upon positive violations of the Articles of Union by acts of the state legislatures, will belong exclusively to the jurisdiction of the state tribunals. Add to this that admiralty causes, and almost all of those which are equity jurisdiction, are determinable under our own government without the intervention of a jury, and the inference from the whole will be that this institution, as it exists with us at present, cannot possibly be affected to any great extent by the proposed alteration in our system of government. The friends and adversaries of the plan of the convention, if they agree on nothing else, concur at least in the value they set upon trial by jury, or if there is any difference between them, it consists in this: the former regarded as a valuable safeguard to liberty, and the latter represented as the very palladium of free government. For my own part, the more the operation of the institution has fallen under my observation, the more reason I have discovered for holding it in high estimation, and it would be altogether superfluous to examine to what extent it deserves to be esteemed useful or essential in a representative republic, or how much more merit it may be entitled to as a defense against the oppressions of a hereditary monarch, than as a barrier to the tyranny of popular magistrates in a popular government. Discussions of this kind would be more curious than beneficial, as all are satisfied of the utility of the institution, and of its friendly aspect to liberty. But I must acknowledge that I cannot readily discern the inseparable connection between the existence of liberty and the trial by jury in civil cases. Arbitrary impeachments, arbitrary methods of prosecuting pretended offenses, and arbitrary punishments upon arbitrary convictions have ever appeared to me to be the great engines of judicial despotism, and these have all relation to criminal proceedings. The trial by jury in criminal cases, aided by the Habeas Corpus Act, seems therefore to be alone concerned in the question, and both of these are provided for in the most ample manner in the plan of the convention. It has been observed that trial by jury is a safeguard against oppressive exercise of the power of taxation. This observation deserves to be canvassed. It is evident that it can have no influence upon the legislature in regard to the amount of taxes to be laid to the objects upon which they are to be imposed, or to the rule by which they are to be apportioned. If it can have any influence, therefore, it must be upon the mode of collection and the conduct of the officers entrusted with the execution of the revenue laws. As to the mode of collection in this state, under our own Constitution, the trial by jury is in most cases out of use. The taxes are usually levied by the more summary proceedings of distress and sale, as in the cases of rent. And it is acknowledged on all hands that this is essential to the efficiency of the revenue laws. The dilatory course of a trial at law to recover the taxes imposed upon individuals would neither suit the exigencies of the public nor promote the convenience of the citizens. It would often occasion an accumulation of cost more burdensome than the original sum of the tax to be levied. And, as to the conduct of the officers of the revenue, the provision in favor of the trial by jury in criminal cases will afford the security aimed at. willful abuses of public authority to the oppression of the subject, and every species of official extortion are offenses against the government, for which the persons who commit them may be indicted and punished according to the circumstances of the case. The excellence of the trial by jury in civil cases appeared to depend on circumstances foreign to the preservation of liberty. The strongest argument in its favor is that it is a security against corruption, as there is always more time and better opportunity to tamper with a standing body of magistrates than with a jury summoned for the occasion. There is room to suppose that a corrupt influence could more easily find its way to the former than to the latter. The force of this consideration is, however, diminished by others. The sheriff, who is the summoner of ordinary juries, and the clerks of court, who have the nomination of special juries, are themselves standing officers, and, acting individually, may be supposed more accessible to the touch of corruption than the judges, who are a collective body. It is not difficult to see that it would be in the power of those officers to select jurors who would serve the purpose of the party as well as a corrupted bench. In the next place, it may fairly be supposed that there would be less difficulty in gaining some of the jurors promiscuously taken from the public mass than in gaining men who have been chosen by the government for their probity and good character. But, making every deduction for these considerations, the trial by jury must still be a valuable check upon corruption. It greatly multiplies the impediments to its success. As matters now stand, it would be necessary to corrupt both court and jury, for where the jury have gone evidently wrong, the court will generally grant a new trial, and it would be in most cases of little use to practice upon the jury, unless the court would be likewise gained. Here, then, is a double security, and it will readily be perceived that this complicated agency tends to preserve the purity of both institutions. By increasing the obstacles to success, it discourages attempts to seduce the integrity of either. The temptations to prostitution, which the judges might have to surmount, must certainly be much fewer, while the cooperation of a jury is necessary, than they might be if they had themselves exclusive determination of all causes. Notwithstanding, therefore, the doubts I have expressed as to the essentiality of trial by jury in civil cases to liberty, I admit that it is in most cases, under proper regulations, an excellent method of determining questions of property, and that on this account alone it would be entitled to constitutional provision in its favor if it were possible to fix the limits within which it ought to be comprehended. There is, however, in all cases, great difficulty in this. The men not blinded by enthusiasm must be sensible that in a federal government, which is a composition of societies whose ideas and institutions in relation to the matter materially vary from each other, that difficulty must not be a little augmented. For my own part, at every new view I take of the subject, I become more convinced of the reality of the obstacles which, we are authoritatively informed, prevented the insertion of a provision on this head in the plan of the convention. The great difference between the limits of the jury trial in different states is not generally understood, and, as it must have considerable influence on the sentence we ought to pass upon the omission complained of in regard to this point, an explanation of it is necessary. In this state, our judicial establishments resemble, more nearly than in any other, those of Great Britain. We have courts of common law, courts of probates, analogous to certain matters in the spiritual courts in England, a court of admiralty, and a court of chancery. In the courts of common law only, the trial by jury prevails, and this with some exceptions. In all the others, a single judge presides, and proceeds in general either according to the course or of the canon or civil law, without the aid of a jury. In New Jersey, there is a court of chancery which proceeds like ours, but neither courts of admiralty nor of probates, in the sense in which these last are established with us. In that state, the courts of common law have the cognizance of those causes which with us are determinable in the courts of admiralty and of probates. And of course, the jury trial is more extensive in New Jersey than in New York. In Pennsylvania, this is perhaps still more the case, for there is no court of chancery in that state, and its common law courts have equity jurisdiction. It has a court of admiralty, but none of probates, at least on the plan of ours. Delaware has in these respects imitated Pennsylvania. Maryland approaches more nearly to New York, as does also Virginia, except that the latter has a plurality of chancellors. North Carolina bears the most affinity to Pennsylvania, South Carolina to Virginia. I believe, however, that in some of those states which have distinct courts of admiralty, the causes depending in them are triable by juries. In Georgia there are none but common law courts, and an appeal of course lies from the verdict of one jury to another, which is called a special jury, and for which a particular mode of appointment is marked out. In Connecticut they have no distinct courts either of chancery or of the admiralty, and their courts of probates have no jurisdiction of causes. Their common law courts have admiralty and, to a certain extent, equity jurisdiction. In cases of importance, their General Assembly is the only court of chancery. In Connecticut, therefore, the trial by jury extends in practice further than in any other state yet mentioned. Rhode Island is, I believe, in this particular, pretty much in the situation of Connecticut. Massachusetts and New Hampshire, in regard to the blending of law, equity, and admiralty jurisdictions, are in a similar predicament. In the four eastern states, the trial by jury not only stands upon a broader foundation than in the other states, but it is attended with a peculiarity unknown in its full extent to any of them. There is an appeal, of course, from one jury to another, till there have been 2 verdicts out of 3 on one side. From this sketch, it appears that there is a material diversity as well in the modification as in the extent of the institution of trial by jury in civil cases in the several states, and from this fact these obvious reflections flow. First, that no general rule could have been fixed upon by the convention which would have corresponded with the circumstances of all the states. And secondly, that more, or at least as much, might have been hazarded by taking the system of any one state for a standard, as by omitting a provision altogether and leaving the matter, as has been done, to legislative regulation. The propositions which have been made for supplying the omission have rather served to illustrate than to obviate the difficulty of the thing. The minority of Pennsylvania have proposed this mode of expression for the purposes. Trial by jury shall be as heretofore, and this I maintain would be senseless and nugatory. In the United States, in their united or collective capacity, are the object to which all general provisions in the Constitution must necessarily be construed to refer. Now, it is evident that though trial by jury, with various limitations, is known in each state individually, yet in the United States, as such, it is at this time altogether unknown, because the present federal government has no judiciary power whatever, and consequently there is no proper antecedent or previous establishment to which the term heretofore could relate. It would therefore be destitute of a precise meaning and inoperative from its uncertainty. As on the one hand the former provision would not fulfill the intent of its proposers, so, on the other, if I apprehend that intent rightly, it would be in itself inexpedient. I presume it to be that causes in the federal courts should be tried by jury, if, in the state where the courts sat, that mode of trial would obtain in a similar case in the state courts. That is to say, admiralty causes should be tried in Connecticut by a jury, in New York without one. The capricious operation of so dissimilar a method of trial in the same cases under the same government is of itself sufficient to indispose every well-regulated judgment towards it. Whether the cause should be tried with or without a jury would depend in a great number of cases on the accidental situation of the court and parties. But this is not, in my estimation, the greatest objection. I feel a deep and deliberate conviction that there are many cases in which the trial by jury is an ineligible one. I think it so particularly in cases which concern the public peace with foreign nations, that is, in most cases where the question turns wholly to the law of nations. Of this nature, among others, are all prize causes. Juries cannot be supposed competent to investigations that require a thorough knowledge of the laws and usages of nations. They will sometimes be under the influence of impressions which will not suffer them to pay sufficient regard to those considerations of public policy which ought to guide their inquiries. There would, of course, be always danger that the rights of the nations might be infringed by their decisions, so as to afford occasions of reprisal and war. Though the proper province of juries be to determine matters of fact, yet in most legal consequences are complicated with fact in such a manner as to render a separation impracticable. It will add great weight to this remark in relation to prize causes to mention that the method of determining them has been thought worthy of particular regulation in various treaties between different powers of Europe, and that, pursuant to such treaties, they are determinable in Great Britain, in the last resort before the king himself, in his privy council, where the fact, as well as the law, undergoes a re-examination. This alone demonstrates the impolicy of inserting a fundamental provision in the Constitution which would make the state systems a standard for the national government in the article under consideration, and the danger of encumbering the government with any constitutional provisions, the propriety of which is not indisputable. My convictions are equally strong that great advantages result from the separation of the equity from the law jurisdiction, and that causes which belong in the former would be improperly committed to juries. The great and primary use of a court of equity is to give relief in extraordinary cases, which are exceptions to the general rules, to unite the jurisdiction of such cases with the ordinary jurisdiction, which must have a tendency to unsettle the general rules, and to subject every case that arises to a special determination, while a separation of one from the other has the contrary effect of rendering one a sentinel over the other, and of keeping each within the expedient limits. Besides this, the circumstances that constitute cases proper for courts of equity are in many instances so nice and intricate that they are incompatible with the genius of trials by jury. They require often such long, deliberate, and critical investigation as would be impracticable to men called from their occupations, and obliged to decide before they were permitted to return to them. The simplicity and expedition which form the distinguishing characters of this mode of trial require that the matter to be decided should be reduced to some single and obvious point, while the litigations usually in chancery frequently comprehend a long train of minute and independent particulars. It is true that the separation of the equity from the legal jurisdiction is peculiar to the English system of jurisprudence, which is the model that has been followed in several of the states. But it is equally true that the trial by jury has been unknown in every case in which they have been united, and the separation is essential to the preservation of that institution in its pristine purity. The nature of a court of equity will readily permit the extension of its jurisdiction to matters of law, but it is not a little to be suspected that the attempt to extend the jurisdiction of the courts of law to matters of equity will not only be unproductive of the advantages which may be derived from courts of chancery on the plan upon which they are established in this state, but will tend gradually to change the nature of the courts of law, and to undermine the trial by jury by introducing questions too complicated for a decision in that mode. These appear to be conclusive reasons against incorporating the systems of all the states in the formation of the national judiciary, according to what may be conjectured to have been the attempt of the Pennsylvania minority. Let us now examine how far the proposition of Massachusetts is calculated to remedy the supposed defect. It is in this form. In civil actions between citizens of different states, every issue of fact arising in actions at common law may be tried by a jury if the parties, or either of them, request it. This, at best, is a proposition confined to one description of causes, and the inference is fair, either that the Massachusetts Convention considered that as the only class of federal causes in which the trial by jury would be proper, or that if desirous of a more extensive provision, they found it impracticable to devise one which would properly answer the end. If the first, the omission of a regulation respecting so partial an object can never be considered as a material imperfection in the system. If the last, it affords a strong corroboration of the extreme difficulty of the thing. But this is not all. If we advert to the observations already made respecting the courts that subsist in the several states of the Union, and the different powers exercised by them, it will appear that there are no expressions more vague and indeterminate than those which have been employed to characterize that species of causes which is intended shall be entitled to a trial by jury. In this state, the boundaries between actions at common law and actions of equitable jurisdiction are ascertained in conformity to the rules which prevail in England upon that subject. In many of the other states, the boundaries are far less precise. In some of them, every cause is to be tried in a court of common law, and upon that foundation every action may be considered as an action at common law, to be determined by a jury if the parties or either of them choose it. Hence, the same irregularity and confusion would be introduced by a compliance with this proposition that I have already noticed as resulting from the regulation proposed by the Pennsylvania minority. In one state, a cause would receive its determination from a jury if the parties or either of them requested it, but in another state, a cause exactly similar to the other must be decided without the intervention of a jury, because the state judicatories varied as to common law jurisdiction. It is obvious, therefore, that the Massachusetts proposition upon this subject cannot operate as a general regulation until some uniform plan, with respect to the limits of common law and equitable jurisdictions, shall be adopted by the different states. To devise a plan of that kind is a task arduous in itself, and which would require much time and reflection to mature. It would be extremely difficult, if not impossible, to suggest any general regulation that would be acceptable to all states in the Union, or that would perfectly quadrate with the several state institutions. It may be asked, why could not a reference have been made to the Constitution of this state, taking that which is allowed by me to be a good one as a standard for the United States? I answer that it is not very probable the other states would entertain the same opinion of our institutions as we do ourselves. It is natural to suppose that they are hitherto more attached to their own, and that each would struggle for the preference. If the plan of taking one state as a model for the whole had been thought of in the convention, it is to be presumed that the adoption of it in that body would have been rendered difficult by the predilection of each representation in favor of its own government, and it must be uncertain which of the states would have been taken as the model. It has been shown that many of them would be improper ones. And I'll leave it to conjecture whether, under all circumstances, it is most likely that New York or some other state would have been preferred. But admit that a judicious selection could have been effected in the convention. Still, there would have been a great danger of jealousy and disgust in the other states at the partiality which has been shown to the institutions of one. The enemies of the plan would have been furnished with a fine pretext for raising a host of local prejudices against it, which perhaps might have hazarded, in no inconsiderable degree, its final establishment. To avoid the harassments of the definition of the cases by which the trial by jury ought to embrace, it is sometimes suggested by men of enthusiastic tempers that a provision might have been inserted for establishing it in all cases whatsoever. For this, I believe, no precedent is to be found in any member of the Union, and the considerations which have been stated in discussing the proposition of the minority of Pennsylvania must satisfy every sober mind that the establishment of the trial by jury in all cases would have been an unpardonable error in the plan. In short, the more it is considered to be, the more arduous will appear the task of fashioning a provision in such a form as to not express too little to answer the purpose, or too much to be advisable, or which might not have opened other sources of opposition to the great and essential object of introducing a firm national government. I cannot but persuade myself, on the other hand, that the different lights in which the subject has been placed in the course of these observations will go far towards removing in candid minds the apprehensions that they have entertained on the point. They have tended to show that the security of liberty is materially concerned only in the trial by jury in criminal cases, which is provided for in the most ample manner in the plan of the convention. That even in far the greatest proportion of civil cases, and those in which the great body of the community is interested, that mode of trial will remain in its full force, as established in the state constitutions, untouched and unaffected by the plan of the convention, that it is in no case abolished by that plan, and that there are great, if not insurmountable difficulties in the way of making any precise and proper provision for it in a Constitution for the United States. The best judges of the matter will be the least anxious for a constitutional establishment of the trial by jury in civil cases, and will be the most ready to admit that the changes which are continually happening in the affairs of society may render a different mode of determining questions of property preferable in many cases in which that mode of trial now prevails. For my part, I acknowledge myself to be convinced that even in this state it might be advantageously extended to some cases to which it does not at present apply, and might as advantageously be abridged in others. It is conceded by all reasonable men that it ought not to obtain in all cases. The examples of innovations which contract its ancient limits, as well as in these states as in Great Britain, afford a strong presumption that its former extent has been found inconvenient, and I give room to suppose that future experience may discover the propriety and utility of other exceptions. I suspect it to be impossible in the nature of the thing to fix the salutary point at which the operation of the institution ought to stop. And this is with me a strong argument for leaving the matter to the discretion of the legislature. This is now clearly understood to be the case in Great Britain, and it is equally so in the state of Connecticut, and yet it may be safely affirmed that more numerous encroachments have been made upon the trial by jury in this state since the Revolution, though provided for by a positive article of our Constitution, than has happened in the same time either in Connecticut or Great Britain. It may be added that these encroachments have generally originated with the men who endeavor to persuade the people they are the warmest defenders of popular liberty, but who have rarely suffered constitutional obstacles to arrest them in a favorite career. The truth is that the general genius of a government is all that can be substantially relied upon for permanent effects. Particular provisions, though not altogether useless, have far less virtue and efficacy than are commonly ascribed to them, and the want of them will never be, with men of sound discernment, a decisive objection to any plan which exhibits the leading characters of good government. It certainly sounds not a little harsh and extraordinary to affirm that there is no security for liberty in a constitution which expressly establishes the trial by jury in criminal cases, because it does not do it in civil also. While it is a notorious fact that in Connecticut, which has always been regarded as the most popular state in the Union, can boast no constitutional provision for either. And so ends Federalist Paper number 83. And that argument, while understandable, could probably have been made in half the time. There was definitely a reiteration of several arguments that definitely could have been a lot shorter. And we're going to have to wrap that up because that was just so very long, and my voice is not going to hold out for 2 more papers, so we'll have a short one to follow this probably tomorrow. Hopefully I brought a little bit of enlightenment and not too much confusion to a not too difficult task. We have the evidence of 250 years to understand that this is indeed how it should work. There hasn't been a whole lot of anything controversial here. It was only controversial then because there were people trying to be controversial. We still have that problem today, so it is what it is. Juries can be subverted. That is definitely a thing, and you can definitely see that happening in New York today. To the crew, thanks for hanging out. I appreciate every single minute that you are here with me, and I am praying for you every single day. Until next time, I love you. God loves you. You are perfect, whole, and complete just the way that you are. And this has been PittCast. Peace.